everywhere. We're child, we legally everywhere. We out here looking into everything. So y'all know I've been doing this learn with me as I'm working through some of this material that I've been working through. So if you're new here, I'm currently working through this 10-week contract law sprint. I did the same thing for criminal law, but with this live is dedicated to a 10-week sprint focused on what? Contract law. It's part of my studies at the University of London, where I'm studying law. Specifically, I have a focus on comparative law and ADR. That's going to be my focus. But as you know, you still got your general courses that you got to take, right? All that foundation you have to lay. So today's focus actually is the foundations of contract law. So yesterday, I'm just going to give you a quick little recap. Yesterday, we built a week 1 foundation. And today, I pretty much wanted to update those notes because I was looking at them like, I could have refined that a little bit better. Y'all know me. If I think there's some refinement needing, child, we finna get into that. So I went ahead and looked into some other notes, added it to the NotebookLM so we can have a new podcast today. And I'm curious what information it's going to give us, because once again, y'all know how I am. I'll throw something in that NotebookLM, which is now, I guess, called Gemini. And I like to see what it's going to say, right? It helps with thinking and processing. I modified my prompt so that it can ask us some questions. So I'm thinking at the points that it's supposed to ask us some questions that we can go ahead and chit chat and talk. Y'all know me. I always got my sketchbooks. I always got my visual graphics. I'm going to put those in the background and let them play. But this specific live, I actually went in and added more terminology because when you listen to the last podcast, I didn't hear much terminology. I heard a lot of concepts, which is fine because we're talking about foundations, but I just really wanted to get some more terminology thrown in there. So we're going to see what happens. Literally, as you know, I don't listen to it before I show it to y'all. So y'all get my live reactions. I'm processing directly with y'all what we are learning together. So pretty much what you're doing today is you're literally just watching my study process in real time. We learn together in real time. We talking in real time. I'm not teaching like I'm an expert. I'm sharing because y'all part of my community. Makes sense? Makes sense. Y'all know I can't give y'all my direct PowerPoints, transcripts, lecture, stuff like that. But I can certainly put that information into something, right? And let us get notes from that. I can certainly share my notes with y'all. There's no rules against that, right? Y'all get where we going. So y'all get the vibe. So essentially, I'm gonna go ahead and give y'all the agenda. What we refining stuff from week 1. Yesterday was day 1 of week 1 sprint. I'm not gonna necessarily do something every single day because, as you know, I'm also working on criminal law material. But I did think it was important that I try to do at least 1 or 2 days each of each week that I'm working on. Right. I'm always doing stuff behind the scenes, but as far as like learning out loud, I want to do that with you guys. So today's focus is going to be a little bit more on legal definition, improving legal vocabulary, connecting concepts together with legal language, and just once again, just building better language for exam because I have to be able to recall, pull, apply, adapt, all that. So I want y'all to have the questions that we're going to start with, right? So the questions that we'll discuss, and I want to say I've chopped this up into maybe 4 or 5 sections, maybe 6. Let me look. Okay, 6 sections, okay? So for section 1, this goes as planned, right? Section 1 is going to be basically what is a contract. Y'all know we discussed that yesterday. What is a contract, right? But I'm interested to see how they're going to set that up. So it's supposed to address, right? It's supposed to address what is a contract, what does contract law, like why does contract law exist? Why does society, let's say, enforce certain agreements? Public law versus private law, civil versus criminal law, and why this distinction is important. That is a big portion of what we're supposed to be doing with contract law week 1, right? Out of my 10-week sprint. Now, do I have this information already put up somewhere on here? Yes, I will show that at the end, but we want to hear what is it going to tell us? How's it going to explain it? I'm always wanting for accessibility, relatability, and just being able to get to them receipts and share stuff. So that's what we're about to jump into. Let me move my screen. So I'm going to go ahead and start that portion of the live. I don't really see any questions at this time. So what I'm going to do is I'm going to jump into that portion of the live. Well, I'm going to let her cook. It says that this generated content will be 24 minutes and 16 seconds. We're going to chop in at certain pieces where it seems like it hits core pieces so we can chit chat and talk. And I'll show you the visuals that I have that are associated with the sections. And that's just going to be our little session today, right? So here we go. Without further ado, I'm going to start to put the podcast on. Going 5, 4, 3, 2, 1.
I want you to imagine a scenario. You're looking out at your backyard, and your fence is just this absolute peeling mess.
Oh yeah, we've all been there.
Right. So you see your neighbor watering their lawn, and you just shout out, "Hey, I will give you $1,000 if you paint my fence." They look over, they nod, grab a brush, and get to work.
I mean, for $1,000, I'd probably do it too.
Exactly. But a few hours later, they are, halfway done. They are sweating in the summer sun, covered in primer, and you lean out the window and shout, "Actually, never mind. I revoke the offer."
Wow. That is brutal.
Yeah. So do you still have to pay them?
Well, I mean, on a human level, it sounds like a simple ethical failing. But legally, it is the absolute definition of muddy waters.
Really? How so?
Because you are looking at a direct collision between, your fundamental right to change your mind and your neighbor's right to be treated fairly after acting on your word.
And welcome to today's deep dive. We are taking you straight into week 1 of contract law.
It is going to be a fun one.
It really is. We have this fascinating stack of sources to go through today. We're looking at masterclass transcripts by Professor Roger Halson from the University of London, recent examiner feedback reports from 2022, stretching all the way to 2025, and various study sketchbooks.
Yeah, and our mission today is to take all these materials and help you think exactly like a top-tier first-year law student.
So we're going to unpack the exact legal mechanics of what actually constitutes an agreement.
Right, and we'll take all that heavy, 19th century legal jargon and translate it into plain English.
Please do.
But most importantly, I think we want to look at how courts actively try to balance strict, rigid rules with everyday fairness.
Yeah, and by the end of this deep dive, you'll actually be able to spot the hidden legal traps in a hypothetical scenario. Specifically, a very messy yacht race.
Oh, the examiner reports love those.
They really do.
Yeah.
Just like a top-tier law student would. But before we can solve that fence painting betrayal, we need to establish what a contract actually is, because reading through Professor Halson's materials, it's clearly not just, a pinky promise.
No, definitely not. Not every agreement you make is recognized by the law. Like, if we agree to meet up for a coffee later and I just don't show up.
Which would be rude.
Which would be very rude, yes. You might be annoyed, but you can't take me to court for a breach of contract.
Right.
For an agreement to actually be born as a legally binding contract, English law requires a few core ingredients.
Okay, what are the big ones?
The big 3 are agreement, meaning a corresponding offer and acceptance. Then there is intention to create legal relations.
Which just means both parties seriously meant to be bound by the law, right? Not just making a social arrangement.
Exactly. And finally, there is consideration.
Okay, let me jump in on consideration, because the study sketchbooks highlight this heavily.
They do, yeah.
If you're new to legal terminology, consideration sounds like you're just being polite or, thoughtful. But in contract law, it essentially means an exchange of value.
Value crossing the road, basically.
Right. It means a contract cannot be a one-way street, like a pure gift. If I just promised to give you a car for your birthday,
I wouldn't say no to that.
and then I changed my mind, you can't sue me because you didn't give anything back.
Yeah.
Value has to cross the road in both directions for the law to actually care.
Yeah, that reciprocity is the engine of a contract. And this brings us to a major dividing line in contract law. We have to divide the entire contract universe into 2 distinct categories based on exactly what is crossing that two-way street.
Oh.
Contracts can be either bilateral or unilateral.
Looking at the notes, bilateral makes intuitive sense. I mean, it's an exchange of a promise for a promise.
Right, a promise for a promise.
The classic example is just walking to a coffee shop. Starbucks promises to give me a coffee, and in exchange, I promise to hand over $5.
And the moment we do that, we are both legally locked in. They have an obligation to make the drink, and you have an obligation to pay.
That makes total sense.
Yeah, that covers the vast majority of commercial life. But the unilateral contract is where things get really tricky, and it's what your fence painting scenario relies on.
Okay, lay it on me.
A unilateral contract is not a promise for a promise. It involves the exchange of a promise for an act.
Like a reward poster.
Exactly like a reward poster.
If I lose my dog, I might put up a poster saying, I promise to pay $500 for the return of my lost dog. I'm making a promise. But I am not asking anyone to promise me they will go look for the dog.
Nobody walking past that telephone pole is legally obligated to form a search party.
Right, they can just keep walking.
Exactly. You are exchanging your promise of money for the actual physical act of returning the dog. The obligation only kicks in for you, the person making the offer, once that act is fully completed.
So initially, the obligation rests entirely on one side.
Yes. And to really understand how courts view this, the masterclass spends a lot of time on what seems to be the most famous contract case globally.
Oh, Carlo versus Carbolic Smoke Ball Company, right? From 1892.
Yes, that's the one. The historical context of this case is just fascinating. It's the Victorian era, right in the middle of a major flu pandemic.
Sounds familiar.
Right. And it's the golden age of patent medicines. These totally unregulated concoctions that promise to cure absolutely everything from gout to baldness.
Snake oil, baby.
Total snake oil. The Carbolic Smoke Ball Company ran this massive newspaper advertisement claiming their product, which was essentially a rubber ball that puffed carbolic acid powder up your nose, would positively cure influenza.
And they went a step further than just a medical claim. They made a very specific financial offer to the public.
They did.
They offered a 100-pound reward to anyone who contracted the flu after using their smoke ball 3 times daily for 2 weeks, according to the printed directions.
And to prove their serious intention to create legal relations, going back to one of our core ingredients, they explicitly printed in the ad that they had deposited 1,000 pounds in the Alliance Bank on Regent Street.
Just to show their sincerity.
Exactly. They were putting their money where their mouth is.
So one day Mrs. Carlo sees this. She buys the smoke ball, uses it exactly as directed for weeks, and she still catches the flu.
Shocker.
Yeah, shocker. She writes to them asking for her 100 pounds, and the company basically laughs at her. They try to argue in court that you can't make a contract with the whole world and that it was just an advertising puff. A joke.
But the court firmly disagreed. They established that you absolutely can make a unilateral offer to the whole world. The company made a promise of reward. Mrs. Carlisle performed the stipulated act of using the ball and catching the flu, and that 1,000-pound bank deposit proved their legal intent.
So the moment she completed the act, she accepted the offer. She won her money.
She won her money.
That sets up a huge foundational rule for us. A unilateral contract only binds the person making the offer once the job is totally finished, right? But, thinking about that rule, it creates a massive logistical problem.
Oh.
Let's go back to my lost dog poster. I put up the posters on Tuesday. On Wednesday, my dog wanders back home on his own.
Happy day.
Happy day for me, yes. But I want to cancel my offer before anyone else finishes the job and comes knocking on my door demanding $500. How do I legally take that offer back if I've broadcasted to the whole town?
Taking the often who walked past a telephone pole or read a specific newspaper.
I don't even know who they are.
So the law provides a pragmatic workaround, which actually stems from an 1875 American case called Shuey versus U.S.
Okay, what was that about?
It was dealing with a reward for a fugitive. The rule adopted is that a unilateral offer made to the public is considered revoked when you give the revocation the same notoriety as the original offer.
Okay, same notoriety.
Yeah.
So if I buy a full-page ad in the New York Times offering a reward,
You have to buy another full-page ad in the New York Times to revoke it.
I can't just put a tiny blurb in a local newsletter and say I tried.
No, you have to match the publicity. If you use the same channel and the same prominence, the law says the revocation is valid against everyone, even if someone who saw the original offer happens to miss the revocation.
Wait, I really need to push back on that because that feels incredibly unfair to the listener.
How so?
Imagine you are the person who read my first dog poster. You decide you really want that $500. You go straight to the hardware store, you buy a $50 heavy-duty headlamp, maybe some hiking boots, so you can search the woods in the dark.
Okay.
You are spending your hard-earned money based on my promise. If I revoke the offer in the next day's paper and you miss it, you're just out that money.
Well, if we look at Professor Halson's masterclass, The courts have a very harsh truth for you in that scenario.
Oh no.
Preparatory expenses are irrecoverable.
Wow.
Yeah, buying a headlamp or boots is preparing to perform the act. It is not the act itself. The act is returning the dog.
Right.
If the offer is validly revoked before you complete the act, the law prioritizes the offerer's right to withdraw over your preparatory expenses.
That is brutal.
Yeah.
So I spend the money, and I just have to hope the offer is still live when I find the dog.
It gets even more precarious for the person trying to claim the reward.
How could it be worse?
Let's say you didn't see the newspaper revocation,
Yeah.
but you bump into a reliable friend in town, and that friend says, "Hey, don't bother looking. I saw the owner walking their dog an hour ago. The search is off."
I mean, I would argue that shouldn't count. Yeah, if I'm entering into a contract with the dog owner, the cancellation needs to come from the dog owner. I shouldn't have to rely on town gossip to know if a legal offer is still valid. Why doesn't the law require the person who made the offer to be the one who officially cancels it?
The courts actually addressed this in an 1876 case called Dickinson versus Dodds. The rationale is based on objective knowledge.
Subjective knowledge.
Yeah, if you hear through a demonstrably reliable third party that the offer has been withdrawn or the property has been sold to someone else, you objectively know the offer is dead. The law won't allow you to pretend you didn't know just because the words didn't come directly from the owner's mouth. If you know it's over, it's over.
So the deck is really stacked against the person trying to do the act. You can lose the offer if they put an ad in the paper you didn't read, or if a friend tells you it's over, and any money you spent preparing is just gone.
It's risky.
But let's escalate this. Revoking before someone starts actually doing the job is one thing. What happens if they are already 99% done? This goes back to the fence painting at the very beginning. My neighbor is halfway through. They are physically applying the paint. Can I just lean out the window and shout, "Offer revoked? Town gossip rules apply? You get nothing."
This is actually one of the most heavily tested areas in contract law exams. It pits that strict legal theory we just talked about against fundamental human fairness.
Because it just feels wrong.
Right. Under the strict rule, you only have to pay upon completion of the act. Technically, a half-painted fence is not a painted fence. You owe them nothing.
But no judge is going to look at a neighbor laughing out the window while someone is covered in primer and say, "Yep, totally fair. It's a total rug pull."
And the courts absolutely recognize that unfairness. The landmark case that shifts the balance here is a 1952 case, Arrington versus Arrington.
What happened there?
A father bought a house for his son and daughter-in-law to live in. He told them that if they paid all the weekly mortgage installments, he would transfer the house to them.
Okay, so it was a classic unilateral offer. A promise of a house in exchange for the ongoing act of paying the mortgage.
Exactly.
So the young couple moves in and starts paying the mortgage week after week out of their own pockets.
They do. But before the mortgage is fully paid off, the father dies. His widow inherits the estate, and she tries to revoke the offer and take the house back.
What was her argument?
Her argument was strictly by the book. They hadn't finished the act yet. The mortgage wasn't fully paid, so the unilateral contract wasn't binding.
Man, if the court follows the strict rule, she just kicks them out.
But the court refused to let her kick them out. They ruled that the offer could not be revoked once the couple had entered upon performance.
Okay, but how do they justify that legally without destroying the whole concept of unilateral contracts?
They used a specific mechanism. They said that by making the main offer of the house, the father also made an implied subsidiary promise.
A subsidiary promise. So they basically invent an invisible, unwritten guarantee that rides alongside the main offer.
That's one way to look at it, yeah. The court implies a promise that essentially says, once you begin performance of the act, I will not do anything to stop you or interfere, including revoking the original offer.
Wow.
Because the couple had started paying the mortgage, that subsidiary promise locked the main offer open, giving them the right to finish the job.
Okay, applying that to my fence, the moment my neighbor's paintbrush hit the wood, they entered upon performance. That triggers the implied subsidiary promise. I can't revoke it. I can't pull the rug out.
Precisely.
So, does Arrington completely solve the problem? Is the ultimate rule that once you start a unilateral act, the offer is permanently locked in?
Many law students make the fatal error of assuming Arrington is an absolute blanket rule.
It's not.
No. The actual rule is that you cannot revoke whenever a subsidiary promise can be implied, but a court will not automatically imply that promise in every single scenario.
Wait, why wouldn't they? If it's unfair to pull the rug out on a mortgage, why would it ever be okay to pull the rug out on someone else who started working?
We have to contrast Arrington with a 1941 case called Luxor versus Cooper.
Okay, set the scene.
The owner of two cinemas wanted to sell them. He offered an agent a staggering £10,000 if the agent introduced a buyer who successfully purchased both properties.
Got it.
The agent went out, did the legwork, and found a willing and able buyer. But at the last minute, the cinema owner changed his mind, revoked the offer, and refused to sell.
But the agent did the work. He found the buyer. Based on the mortgage case, he entered upon performance. Why wouldn't the court imply a subsidiary promise to protect him from the cinema owner just backing out?
This case went all the way up to the House of Lords, the highest court in the UK at the time. And they held that the cinema owner was entirely free to revoke the offer, and the agent got absolutely nothing for his trouble.
I genuinely don't understand that. How can the court protect the young couple paying the mortgage, but completely throw the commercial agent under the bus when he did exactly what was asked?
It comes down to a concept called business efficacy, and specifically the proportionality of the reward.
Proportionality, okay.
The House of Lords looked at the sheer size of the payout. In 1941, £10,000 was a monumental fortune. The court explicitly noted that this reward was higher than the annual salary of the Lord Chancellor.
Wait, the head of the entire judiciary?
Yes.
Oh, I see. They are looking at this guy demanding a payout bigger than the top judge in the country just for making an introduction.
Right. The court reasoned that for such an astronomical reward in exchange for a relatively small amount of actual labor, they did not need to step in and imply a protective subsidiary promise to make the contract function.
So the massive reward completely justified the risk of the rug being pulled.
The court essentially said, for that kind of windfall, you take your chances, you know it's a gamble.
That completely reframes how we look at these cases. It's a sliding scale. If the reward is proportional to the heavy labor, like paying off a house for 20 years or spending all day painting a fence, the court implies a promise to protect you because it's the only fair way the deal makes sense. But if the reward is wildly huge compared to the work, the court steps back and says, no protection for you. That was a risk you chose to take.
It is the courts actively calibrating fairness based on the commercial realities of the situation.
Okay, we have all our building blocks.
Huh.
We have Carlyle showing how money in the bank proves legal intent.
Yep.
We have the rules for matching publicity and third-party gossip for revocation. And we have the clash between Arrington and Luxor regarding pulling the rug out mid-performance.
We've covered a lot.
We have. So let's take all of this and do what the examiner reports say separates the passes from the fails. Let's apply this to a complex, real-world scenario.
The hypothetical presented in the University of London masterclass materials is perfect for testing these boundaries. It centers on the Royal Yacht Club, or RYC, holding a regatta.
Okay, put yourself in the shoes of a sailor in this town. The RYC puts a large notice up on its clubhouse door. It says, a prize of £5,000 has been deposited with our bank to be paid to the winner of our yacht race on April 1st.
Okay, pause there.
Right, because looking at my notes, the phrase deposited with our bank is a massive red flag for a law student.
It is.
That is a direct callback to the Carlo smokeball case, stating the money is in the bank proves their intention to create legal relations. We are dealing with a valid unilateral offer to the world.
Spot on. The examiner breaks this down into 4 distinct scenarios to test the nuances we've discussed. Let's start with scenario A.
Right.
It's 9:00 a.m., an hour before the race starts. A sailor named Aphrodite is on her yacht, getting ready. Over her radio, she hears 2 rival yachts talking, saying the race has been completely canceled by the club.
Oh, man.
She is furious because she just spent a fortune buying a brand new, expensive set of sails specifically to win this race. Can she sue the RYC for the prize money, or at least to get the money back for her sails?
All right, applying the rules to Aphrodite. First, she hasn't started the race yet, so she hasn't commenced performance of the stipulated act. But she did buy those expensive sails.
Right.
That is exactly like the listener buying the $50 headlamp to look for the dog. As we established, preparatory expenses are irrecoverable in unilateral contracts. Buying sails is preparing to perform, it's not racing, so she can't get that money back.
But what about the fact that the RYC didn't tell her directly? She just overheard it on the radio.
Ah, that brings in the 1876 third-party rule, Dickinson versus Dodds, right?
Yes.
Revocation doesn't have to come from the club. Overhearing other racers on the radio likely counts as hearing it from a reliable source. She objectively knows the race is off. So the offer was validly revoked before she started, and her prep expenses are her own problem. She has no claim.
A perfect methodical application of the rules. Now, let's look at scenario B.
Let's do it.
A sailor named Bacchus is actually in the race. He was leading the pack and is just 20 feet away from the finish line.
The tension.
Right. Suddenly, the club commodore, standing on the dock, shouts through a megaphone that the race is abandoned. And the facts tell us the commodore hates Bacchus because he drinks too much wine.
Of course he does.
Can Bacchus claim the prize?
Okay, this is the classic mid-performance rug pull. He is inches from completing the act. This has to be an Arrington situation.
Walk me through it.
He has clearly entered upon performance of the stipulated act by racing. And 5,000 pounds for the immense effort and skill of sailing a grueling yacht race seems proportional.
Right.
Because of that, the court would almost certainly imply a subsidiary promise that the RYC cannot revoke the offer once the race has begun. The Commodore's megaphone shout is invalid. Bacchus should win the money.
The court would indeed protect him
There
against
is
that bad
it.
faith mid-performance revocation. But let's twist the facts for scenarios.
Yeah, twist away.
It is the exact same physical situation. Bacchus is 20 feet from the finish line, Commodore shouts through the megaphone. But the original prize offered on the poster wasn't 5,000 pounds, it was 50,000 pounds. Does that alter your analysis?
Oh, this is where we bring in the cinema case, Luxor.
Exactly.
If the prize suddenly jumps to 50,000 pounds, the consideration has become unusually massive compared to the act of a local yacht race. A judge might look at that 50 grand and say, you know, for that kind of windfall, you took a risk.
It just might.
They might refuse to imply the subsidiary promise, which means, shockingly, the RYC might actually get away with revoking it at the last second, just because the prize was so high.
It's a fantastic pivot. The examiner reports specifically highlight that spotting the distinction between the protective rule in Arrington and the risk-taking rule in Luxor, based entirely on the proportionality of the reward, is what separates an average exam answer from a brilliant one.
That is so cool to see it in action. Okay, final one, scenario D.
Scenario D. A sailor named Cheat is losing the race. He's right behind the leader, Dirk. Desperate to win, Cheat turns on his yacht's hidden engine, which is strictly forbidden by standard racing rules, and he zooms across the finish line first. Does Cheat get the money?
I mean, his name's Cheat.
Right, but legally, why does he lose? This requires returning to the very foundation of acceptance in a unilateral contract. You have to complete the stipulated act. The offer was for the winner of a yacht race. Implicit in the very definition of a yacht race is that vessels are propelled by wind and sail, not by a motorized engine.
So, by turning on the engine, Cheat didn't actually perform the act the RYC asked for. He performed a completely different act, a motorboat race. Therefore, he never legally accepted the offer, and he gets nothing. Perk, who followed the rules, should win.
Strict compliance with the terms of the offer is non-negotiable.
So bringing all of this together, we started with a sweaty neighbor painting a fence and ended with massive windfalls and yacht races. But the underlying theme here is really striking.
It really is.
Courts are not just acting like mindless dictionaries, matching words to rules. They are actively engaged in balancing individual freedom. Your right to cancel an offer you made, with fundamental fairness protecting people who have already poured their sweat and money into the work you asked them to do.
That tension is the absolute heartbeat of contract law. And if I can share one final crucial secret straight from the examiner's feedback reports for the listeners. The way to conquer any contract problem in real life is to analyze the facts strictly chronologically. Yes. You cannot jump to the end of the story to see who got hurt. A later communication, like a megaphone shout, only matters based on how you classified the very first poster on the wall.
That makes total sense.
Start at the beginning. Decide if it's an offer. See if it was accepted or if it was validly revoked first. Sequential analysis is how you win.
Follow the timeline. Don't skip to the last page. Well, before we wrap up this deep dive, I want to leave you with the final thought to chew on.
Let's hear it.
We just spent a lot of time discussing how courts will imply terms into our agreements to make them function properly. They invent a subsidiary promise out of thin air so you can't revoke an offer unfairly on a mortgage. They imply that a yacht race naturally means using sails, not engines.
Right.
If a judge has the power to inject unwritten rules into our agreements just to give them business efficacy or make them fair, are we truly bound by the actual words we say to each other? Or at the end of the day, are we ultimately bound by what a judge sitting in a courtroom thinks we ought to have meant?
That is the beautiful, entirely murky reality of the legal system.
So next time you look out the window and ask your neighbor to paint that peeling fence, maybe just put the whole thing in writing first.
Definitely.
I hope they don't buy an expensive headlamp before they start.
That's funny. All right. So that was the podcast, right? That was kind of interesting. Definitely some different pieces than the one we had yesterday. How did you guys feel about the incorporation of language? I definitely feel like we had a lot more cases being cited, which was really interesting. That's going to bring us back to some of the original questions we started with and see if we can fill them in, right? What are your thoughts? Sound off in the chat. Sound off in the chat. I'm trying to pull up my secondary one, which actually answers some of the questions in case you guys wanted that for your own information. It's not pulling it on the screen. So we're going to try this one more time so that you guys can see it on the backdrop. So, reasons. Okay. So, big bucks, no whammies. We're going to see if we can get this one up. Let's see. Okay. I think we have it. See if it loads. Okay. So, what we've discussed thus far, right? The conversation has been, so before I put it on the screen, back on the screen. So the week one focus, right? So essentially, let me go ahead and rewind us back. So right now I'm doing a 10-week sprint using a project management style approach to getting through this material, right? And sorry, my little Frenchie tried to grab my cookies that I'm gonna have as a treat after studying. Gotta watch him. You gotta watch him, my little Frenchie. So essentially what we're doing is we're doing a 10-week sprint. It's a project management style approach. I felt that would make it easier for me to break down and digest the information because obviously I read through the material, but I wanted to make sure I could actually apply the material and I can kind of discuss it within fixed time frames. And I want to just feel like my approach is if I can share the information, explain to someone else, then I have it down. But if someone asks me a question, I can't explain it, that means that's the gap in my learning and that's where I need to kind of go back and study. So that's one of the reasons I love to do these learn out loud sessions with me, because I sometimes will see like, hey, I thought I had that down, and then in actuality, I did not have it down as much as well as I thought I had it down. So what I've been doing is I've taken all the content, the exam, that I actually have to do 2 parts to this exam. So you have like the multiple choice portion and you have like your written piece. The multiple choice is next month, and then the following month will be the written portion. I had exactly 10 weeks from start to finish at this point. And so that's why I'm breaking the information down from the foundations, from the very beginning. What is a contract, all the way down to all the other pieces, from citing cases to being able to do the written pieces, right? I want to do all of that. So that is how we kind of came up with this sketchbook. I'm actually going to fill in some of these answers as we move through the rest of this live today. So the focus for week one, let me zoom in my question a little bit more. Okay. So week one focus, I'm going to show you this right here. If we look, let's see. Week one focus is what is contract law, right? So we heard that the podcast gave us actually quite a few of these answers, right? So, what is a contract law? So, what is contract law, better yet? Why contract law exists? Functions and purpose. Freedom of contract, the source, common law, legislation, doctrine of precedence, role of judges in developing contract law, English court structure, civil versus criminal law, relevant to, contract law specifically. You probably want to see that, right? Private versus public law, life cycle of a contract, the introduction to contract formation, key terminology, and that, like how week 1 pretty much will connect to upcoming weeks, which will be next week's material. That's the structure for today, okay? That is the structure for today. We did a little bit yesterday. I modify the prompts just so we can kind of get a little bit of sauce, a little bit of different flavor each podcast, because we don't want to hear the same exact thing, right? But today's focus is more so on legal language, because as we see, a big portion of, I shouldn't say a big portion, but a portion of this was key terminology, right? So I wanted today's function and focus to be more so on the terminology. So that's today, right? I'm going to actually go in and show you the one where I started to fill it out. Because y'all know I was sitting studying, so I've been working on this, but I do the learn out loud so that we can learn together. Because y'all always come up with interesting things or approaches and ways of looking at things. And I'm like, okay, I didn't see it that way. Or maybe I'll listen to myself, because sometimes I'll go back and listen to the lives. I'm like, okay, I could have refined the way I said that. I could have made it more concise. Or maybe I should have given you guys more detail. Whenever I notice that, I come back on the next live and I do refinement. Today is a refinement. I didn't think we had enough terminology focus yesterday. So I went in and put the definitions like, hey, give me more of this. Because this is the podcast portion is AI generated, and I also don't listen to it before I come in. I come in blind so I can have genuine conversations with you guys and genuinely process it out. So you literally get to experience my thought process as I'm working through it. Not just like, oh, I already pre-did all this stuff. No. The graphics, of course, I pre-did. I wouldn't sit online and just be typing. So we'd be doing this for hours, okay? Hours. But the process I share with you, if that makes sense. Did that answer your question? Oh, and thank you. Oh, you guys are so kind in the comments. Okay. So let me pop out because it probably needs to reload. I just updated this. Hey. Okay. So if you look in, okay. So if you look, this is the version where I'm actually filling in the questions. So the first one kind of starts as a worksheet for me, and I kind of work through the structure I give myself, right? So this is answering a lot of the questions. As you see, we go from 1 all the way down to like 13, I believe. Right? So it goes from here all the way down, right? Hopefully that's not causing any visual discomfort with me moving my hand like that, right? So as you can see, I have some portion of those answers there. Okay, I'm gonna put it like that so y'all kind of somewhat see it behind me. I see in the chat, where am I from? I am from Michigan, and thank you. Best of luck. Thank you. I hope you subscribe and stay a part of the community. Hope you stay and check out what we're doing. I've been having so much fun when you guys chat with me and interact. I really enjoy the engagement in the chat. Like, it helps me kind of like move through things, talk through it. Because otherwise it just feels like you're just sitting online doing a whole monologue. That's not my thing. I genuinely enjoy lives because it gives me a community. So I have so much fun with this. And so thank you so much for the engagement and the support, because it really is helpful. You know, this is a newer experience, you know, going, you know, looking through the material and, you know, going through this process the way that I'm going through it. I've adapted a lot of things I did my first go around in school over a decade ago. So luckily, I'm able to incorporate AI in this process. I'm also not a traditional student by pretty much any metric of the word. So I'm trying to find ways to really make sure it fits where I am and who I am, because, you know, your background, I always believe, is something you can leverage and you can include as you do whatever you're trying to do, whether you're transferring into, or let's say shifting into different professional careers or whatever the case may be. I always feel like you don't have to abandon whatever you did in the past. You just have to figure out how you can transfer it, how you can modify, how you can adapt. So, me being a very visual person, I love these graphics. I love the visuals. It definitely takes a little time to put together. But for me, it's very satisfying once I see it, because I've always been someone who would write it all out. And I'm getting older, your hands get to all crabbing up. You know, the past, 10 to 15 years, people aren't writing as much. We type or we vocally, you know, have things written out. So it's a little bit of a different thing. Your hands cram up a little bit more. So it takes a little bit of work to do this. But luckily, I'm able to utilize technology to kind of fill in the gaps. I'll start some stuff out and it says, oh, I see what you were thinking about. I see where this was going, and boom, you know. I don't think you can expect it just to pull things together for you, but if you lay out the idea, if you have enough information, they can kind of gel things that reasonably make sense. When I use it, I definitely say to use all of my resources and don't like deviate other places. Like whatever I present is the authority, is the authority. So that's how I use, I feel like, AI responsibly. Especially with regards to like my notes and stuff. I don't ever want to see that my notes and the main things that I'm stating were, like, let's say, cited or whatever the case may be, are modified. So for me, that works. I've read some things that kind of make me like, wait a minute, is AI doing that? You know, but it didn't affect me that way. But I put in control factors. You know, I guess it's all in the prompts, maybe. Okay, so back now I went on my little tangent. Yeah, I would say this particular session felt comfortable in the sense that I really definitely felt like I was hearing more of the language about how I could tie in. So when I think about how I might want to write certain pieces, I definitely feel like this particular podcast would help me with that. I could see the flow and movement of how you might set up your written pieces. So that was helpful for me. Let's see. Just for the sake of conversation, we can also let us see. Hopefully you can see. Can you guys see the image behind me? I know it's probably not as clear because I don't have this close to the camera. But as far as the life cycle of like a contract, right? Like for me, I think one of the biggest pieces was I've been connecting everything directly to where would it fall in the life cycle, or if it falls in the life cycle. Because if it's not in the actual life cycle, then what is not a contract? So then we'd be discussing that piece, right? Because some of the vignettes or the cases, the examples that they give us, sometimes you'll find that, oh, maybe that actually wasn't even a contract based off of the positioning or the posture, right? So that's been fun too. I think initially I was kind of throwing myself off with certain pieces, and I realized that earlier today. And I said, hey, it's time to do some refinement. And that's how we got to this particular point. But just to go through the life cycle of a contract, just because we're here, right? You start off with the offer, right? And one party makes a clear, right? A clear offer. Then the next step would be the acceptance. The other party accepts, right? That's this blue one right here. And you see we're going to move this way. So the other party accepts. Then you can move into the portion called consideration. So something of value is what exchanged. The next portion would be intention. Both parties intend to be legally bound, right? Next portion will be contract is formed. So legal obligations arise. Then the next portion would be the performance or what? The breach. So rights and remedies follow that. So when I mentioned these pieces here, we want to think, what is the offer? An offer is a very clear proposal by one party to enter into a contract. And then you have the acceptance. That's the agreement to the terms of the offer, like you specifically agree to that offer. Consideration, so like value, something given or done in exchange. Intention is to create like legal relationship. When we use the word capacity, we're thinking about legal ability to enter into a contract. My example yesterday was, we wouldn't get into a legal contract with a 3-year-old, right? You wouldn't do a legal contract. They're not legally capable of consenting. They're not legally able to enter into a contract. So that is not appropriate. Therefore, that would not be an actual contract, right? You could do it with their legal guardian, but you couldn't just have a legal contract with a 3-year-old, right? So legalities. The contract's purpose must be legal. You can put people on legal contracts for illegal activities, right? Because that wouldn't be enforceable by law. If that makes sense. You know what I'm saying? So kind of putting it that way. Let's see, what's another piece? This shows like the legal court structure. I don't know for live if you guys are all the way interested in that part, but listen, we out here, right? So why not? That would be your court structure from the England-Wales perspective, right? From which I am studying. So you have the final court of appeals, which is at the very top, your Supreme Court. But if you think about it, your actual baseline is right here. So your magistrate's court, your first instance of pretty much hearing something, your lower level court, criminal and some civil situations. Then you go up to your crown court, serious criminal cases. Then you move up to high court. Then you will go to the Court of Appeals. Then you go to Supreme Court. So that would be, that structure. So I feel like week 1 takeaway so far is contract law enforces promises and protects expectations. I feel that takeaway number 2 I have is that freedom of contract is important, but not unlimited, okay? I think so far takeaway 3 is common law and statutes work together to govern contracts. I feel that courts play a key role in interpreting and developing laws, and understanding the basics builds everything else. It's like math, you got to make sure your foundation is good or stuff gets real janky real quick, right? So I've been telling myself just to kind of slow it down, because sometimes I'm like, okay, what case law I want to jump into? And sometimes you throw yourself off when you just automatically, I was so quick on pattern recognition and issue spotting. Sometimes I was jumping the gun a little bit, as they say. So we don't want to jump the gun. So I've been enjoying going live and talking to you all, listening to my process, requiring myself to go through the process. I actually did a study group today, and I liked being able to hear my process. And I was like, you know what? Boom, we need to study some more, because anybody knows me, I'm a little particular. I don't know if the visual graphs gave you that inclination, but I am a little particular. And I said, you know what, now that I see that I need that refinement, you got to move on it. I'm very big on, if you see that there's something you need to address or do better, you do better, right? So I did that refinement today. I didn't want to let it go too far, which once again I find to be quite helpful. Let's see. Oh yes, putting us on the slideshow, so I don't gotta keep clicking on this thing. Let's see. Was there any other piece I want to go over right now? Did you guys have any questions? Because there was a couple of cases that kind of came up. but we can make tomorrow or maybe the next day. Give myself a break. The case law day. No questions? Hey, that's good. That means I did a good job. I did a good job of sharing if there's no questions. Although I know it was a lot of information. I felt like I was like, bing, bop, bing, bop, bing, bop, bam. No, like I told you, I try not to keep y'all too long. I'm glad that you're enjoying this content. As you know, on top of just doing, outside of just doing the contract law study with me, I also do the criminal law study with me. So some of you all, I can see from the chats, are familiar with what I was doing with the criminal law case study, which I started before this one. This one started this week. I've been doing the other one a little bit longer. I always try to do a case study. A case study helps me process everything. As I'm moving through it, I can say, okay, let me apply it to something real, because that's when it gets juicy. And that's when it gets really like, okay, I know what's going on. Moving through a real active case. Like, what does that look like? Or some type of active news information that looks like it could be relevant to a case, right? So with this one, right now I'm looking at a Reuters article clip that came out about the Trump organization and Capital One, because I was like, oh, that's very interesting. That definitely sounds like there's some contracts involved. If they said that 300 accounts got closed, and there's some back and forth about that, some federal complaint filings and different things. I was like, okay, there's some appeal discussion. I said, that seems like we got a little bit of something to chew on and work with. We could find some court filings or at least something. When it's a little bit more public like that, we can get more details, because somebody's going to be talking about something. And luckily, there's news articles and nothing else we can kind of play with. Although I do suspect in the next couple of weeks, we'll probably actually have some court filings I can pull, because, you know, I'm really big on getting those primary sources. So we'll kind of dig into that as like a case study. And for other people who have been on, like I said, the other content that I was doing criminal law, you know, learn with me, and then also learn with me through the lens of, and I've been looking at criminal law and then doing it through the lens of the Nolan case. Once again, that particular situation, I try my best to be very trauma informed, because once again, it's an active case, open investigation. There's a lot of emotions around that, but I also think that's a really good opportunity to kind of look at what might it look like to be navigating those types of situations, those kind of cases, looking at it real time, right? What does that look like? So I might be able to go live again today with a little bit of an update. I do have something I'm going to go ahead and try to put together in a little bit to come back on live. I like to give myself a break in between going live. But we do have a little bit of an update that I can provide. I either try to do the learn with me or the case study. Sometimes I can do both, just depending on how much information I feel like I've gotten access to that I think we can actually do as an update. But yes, I always put it through the study material and then also the Legally Everywhere framework, because as you guys know, I do have a Legally Everywhere framework that I use on this channel, just to kind of put things in perspective. Let me actually show you what the Legally Everywhere framework as the actual visual. Okay. So from the case study perspective, when I did it, this is what it looks like. So you see there's these different sections, right? We talk about historical patterns. We talk about strategic actors, geopolitical context. We talk about legal authorities. We talk about the mediation perspective. And then from all of that, we're kind of talk about the impacts and the power dynamics. How does that impact the individual, right? Y'all know that formal social work training, right? I'm always interested in harm absorption, like how do we absorb the impact of decisions that are made, right? Often in rooms that we are not in. What is that? What are the power dynamics associated with that? So that is the one that I started looking at. That doesn't necessarily mean that's the one we'll end with, we might find another contract case that makes sense, right? And that's why I say if y'all go into these chats and y'all give me a good one, we can use that one. Sometimes I might do more than one. We don't know. I'm all about the learning process, so if it makes sense, I'm okay with it. But I think it does make sense to try to follow one all the way through as best we can. But if there's another case that just seems a little bit more juicy, a little bit more, then hey, I'm all for it, right? I don't mind snacking on one of these good cases and diving in and doing all the application that we need to do so we have it in our minds. Like, how do we apply these skills? How do we ask the question, the important question, the correct question, more the right question so that we can get to a more ideal outcome, right? We want to understand. Sometimes you ask questions and you just have informed uncertainty, which kind of sometimes just is the case. But if that's the case, I would rather be informed and uncertain about, next movements than just to be uninformed and uncertain. If I gotta choose, I'm going for informed. So that's where I sit in that perspective. Just so you can also see, we're talking about the criminal law pace with Okay, so if we talking about the criminal law, this is what that evidence, timeout, and critical thinking case study looked like with Nolan for criminal law. So if just a little sampler, you kind of see this was, I believe from part. So I don't have a clue what that camera just did, but child, we was wrapping up anyway. I just want y'all to see this was the board. So if you're interested in criminal law by any chance, we also are doing a study with me, learn with me with criminal law. And the case study focus is the Nolan Wells current investigation, like that current case, right? We're looking at that case as a case study. And then once again, if you're interested in contract law, like you were here today, we'll definitely be looking at that Trump organization versus Capital One and seeing what kind of juicy details we can get from there. If there's some other cases that come up, I might entertain a second case study, just because I really want to make sure I'm able to apply the skills and that we have it down, right? So once again, this is Legally Everywhere with Child. Look, we legally everywhere. We looking into everything. This is week 1. This is week 1 of the 10 weeks of sprints through the contract law material as well as the criminal law. Today, we were looking at contract law, or more so during this live, we're looking at contract law material. I hope that you're thoroughly enjoying this and having fun with me. This is fun, right? It's exciting. If nothing else, it's very informative. Hope that you're enjoying this. And if you like this material, like, comment, subscribe. For me, one of the biggest things is I love the engagement. I love the comments. I love to see what you guys have to say, how you're feeling about it, like how you're processing it. I enjoy that portion. But, once again, it's important to like, comment, subscribe. Share if you find that there's someone else who might like the material. I appreciate you sharing it with them so we can build out this community and we can have more people in the chat to talk to. Right? This is just like, it almost feels like show and tell from back in the day when we were younger, right? Show and tell. So I was able to show you what I've been working on and tell you all the things that I've been learning, and y'all been able to tell me what you see and what you think. So once again, it's Legally Everywhere with Child. We're legally everywhere looking into every single thing. This is Adrian signing off, and I'll see you in the next